What?
The Crow Line had a couple hours to get it ready.
Mm-hmm. You're on mute.
You gonna throw pork? Shoot.
Perfect. Nice.
Hey there. Send me an invite. Just 1 minute, Tidy. Are you already out of HG in the court or no? Okay, got it. Didn't you just create a portal? Sure you can. There's a code that you can use for it. Never mind. Don't worry about it. Okay, so I'm going to join you. And then I'll send an invite to the others.
So are we to assume that the
Okay, so I'm in here.
Oh man, you wanna play the
Okay, drop in the group. Drop it exactly.
So are we?
Headset's already
That's okay.
low.
Are we good to assume that the evidence is already sworn in and everything,
I can
so we don't
plug it
have to
in.
go through it all?
I had it.
Awesome.
I had it ready, and 4
Thanks.
o'clock I got on, and it was full 100%, and now it's giving me messages it's low.
You do have your white Bronco that you could jump in and go take a drive.
He never did that. He never did that. He never did that. Don't say a goddamn word. Play the fifth.
It's not the fifth.
I said that. The fifth.
The fifth. The fifth.
Fifth. The
old man is gonna be Cochran.
hello.
And are my witnesses here?
Fuhrman's there, Ryan.
Oh, I don't know.
Ryan is Fuhrman.
This is gonna be tough. This is gonna be tough. Yeah, okay.
Plaintiff or defendant?
Letisa can be something too.
Keep in mind, unlike Cochran, I am wildly unprepared for this trial. I do not know who
Sarah.
Well, wait, then Let's see. I can't send it to you
Huh?
now.
Let's see.
Is she invited? Okay.
So
Who's Tiger? Or Tiger?
see.
Tiggy.
Damien.
Somebody's- I don't know. Somebody started involved. Called me. No, Tiggy.
Wait, he said he's
got
one of the kids from the other court.
200.
Jason. Where's Jay? Jay's not here. Okay, so there goes one of my witnesses. Punchy? No Punchy.
To what
Okay,
level
so
of
are we
faithfulness
playing
is
multiple
this
personalities where I can
Punchy.
play all my own witnesses?
I'm
Shocker is
Punchy Dewey.
punchy.
Am I playing multiple personalities? Because I don't have any witnesses.
Shocker is punchy.
Who's?
Shocker.
Oh,
501 is punchy.
I didn't know you went by Punchy.
What's Punchy Dewey?
Okay, so I have one witness.
And which witness are you?
Gary Sims.
Okay.
Okay.
To what level of faithfulness to the OJ trial is this going to be?
It's gonna be bastardized.
Vaguely, that is the answer I was hoping for.
The defendant is named OJ and he
Yeah.
killed his wife. That is all.
Beautiful. All right, never mind. This is not what I was saying. My
Jules
favorite part
just
of the
came
trial
on
is when he
again.
put on a beanie at the end of it and said, "I'm still Johnny Cochran in a beanie." That's a scary thought.
Well, and all the witnesses come in here. So, Desert, you can just come stand in here and
Yeah,
Shocker,
stand
you
by
just stand
who
over
you're
there.
witnessing
Who's Desert?
for.
and
I know I'm
Ryan.
supposed to
Right here.
dress
Oh,
up.
no.
Or not.
No,
That's
I
why
mean,
asked.
who are
Ryan
you?
is Fuhrman.
I'm Arnell Simpson, his daughter.
Okay. Oh, that's not
Oh, you're
biased at
Fuhrman?
all.
Yeah, yes, ma'am. I'm Detective Fuhrman.
What do you
What do
mean?
LAPD.
She testified in the trial
19
twice.
Very
years and
good.
6
Oh yeah, I
months.
know.
That me.
What'd you see? I should know that.
What did I see?
Yeah, I gotta direct you. I feel like
I didn't see anything. All I'm talking about him. I
What you
didn't see the. I didn't see the murder or nothing like that.
Jules, I thought you said you weren't going.
what do you testify to? His
You were on
character?
some vacation or something.
She's
I
the
think
bailiff.
probably a character
or
witness.
jury or what?
I think
You're
the first-
useless.
The first date.
No,
he chose
Who are you
Lincoln.
playing?
The first date.
I'm one of the ones that went to the prison and talked to the prison people over there and had him get out of the prison.
Oh, so you bailed him out?
He didn't go to prison for this.
Yeah, no.
Well, he was let out.
No, I
Jail.
know he
He was
did.
in jail.
I read the
Jail.
trial.
Yep.
He did go to prison though, but
You
it
know,
wasn't
I
over
began
there.
He did
watch-
go to jail. He
I
did.
began
Civil
watching the
side.
Johnny
I love
Cochran
Roller
Cochran
Gracie's wearing
closing,
a football.
and then I got 4
outfit
parts in
today.
and realized I still had 4 left,
The
and it was an
Heisman
8-hour long
Pros.
closing, so I gave up.
Oh,
Yeah.
Fair and the
I
judge.
crammed too.
You don't
I'm-
recognize Judge Ito?
And one of the parts she talks about how hold on, give me a second.
Dang.
How he was upset
I've been
and
on
how he was in
something
shock.
I,
for almost
uh,
20 years.
Are you
Yeah.
playing his
I had
daughter?
something-
About it that
Yeah.
I've
I
seen.
looked at you and I was like,
I'm
what
on it.
happened?
Got it.
Ryan? And
Okay,
then
so
I
you
know it's
spoke to
always
him
the
after the
OJ
fact.
thing.
I had a
I
rough
would
night.
know if during the killing when they
Rough
come
night
over
with
and accused him, he was supposed to have been with
Let's
me
do a
and
party,
something,
guys.
Sure.
and
Yeah, we
I
need to
knew
get
he,
into
he was
party,
upset
too.
and stuff.
Oh, he was
I
with
had
you
to
at the time
party.
of the killing.
The party.
Go.
Yeah, I need to talk to Fish a minute.
I'm deposing my witness.
Can
the
I
day of
talk to you in
trial.
private? Okay.
Wow, we have a lot of people on the plaintiff's side, not so many on the defense side.
Okay.
This should be interesting. Ladies and gentlemen.
Let Lisa in so she can play something potentially.
Okay.
Bailiff or whatever.
Thanks, man.
I might have a little bit problems
Does anybody see?
because
Does anybody see?
I might
any
have a little
of
problems
our
remembering
regulars
what
for the
she's
court?
supposed to say because the doctor said
really,
that
no.
I'm having. He thinks I'm having.
No, you have to pay
silent mini
attention really
strokes.
well. Sorry, Judge.
Okay.
Judges don't pay attention.
Okay.
At least not to my court case.
All right.
Yeah, the judge is
Actually, guys, everybody knows what I do for a living. I just had one of my court cases accepted to the Supreme Court yesterday. So, no, sorry, not yesterday. On Friday, we just got notification from the Supreme Court. For those of you who may not know, that is the Super Bowl of the legal field, having a court case, the immigration case that we were shocked that the court allowed it, and they accepted our writ of cert. So it's my second case filing to the Supreme Court, my first one ever admitted in over 20 years. So incredibly cool that was done. Okay. Very good. Ladies and gentlemen, I am Judge Ito. This is the state versus Mr. O.J. Simpson. And as Judge Ito, this previously was an 11-month trial, but this is not going to be an 11-month trial tonight. It's going to be about 1 hour. So for attorneys, I'd like you please to always, when you're standing up or calling a witness, please introduce who they are and what part that is that they're going to be playing. Witnesses who are going to be testifying, please state what your name is for the case. And I think that we should be sworn in according to the metacourt way of swearing people in as opposed to an actual court. As a reminder, we want to have fun. We want to have a good time with this. And we are not sticking with the facts. Let me emphasize the word not. So while we're using that as the guidelines for it, today we can either prove or disprove OJ guilty or innocent. And I don't care whether the glove fits or he needs to be acquitted or anything else. It is up to you guys to prove beyond a reasonable doubt that he is guilty or innocent of this case. Everybody understand our rules for tonight? Yes. Miss Martha, yes. Very good. Okay, Miss Martha, are you ready to proceed for the state?
Sure.
And Mr. Old Man Music, what part are you playing, sir?
I am Johnny Cochran, appearing for the defense, Your Honor.
God help us.
I just
Okay.
went off party because I couldn't hear.
Agreed, Your Honor, for the record.
Can you hear me?
And thank you very much,
Megan
Mr.
says she
Cochran.
cannot get in here.
And if the state's ready to proceed, please begin, ma'am.
Okay. All right. He said he'll check it out, Megan.
Thank you, honorable jury, taking your time being here this evening. We're going to try and make this short and sweet. Our evidence will prove that Mr. O.J. Simpson killed his wife and a poor, very sad waiter that was just coming to bring her mother's glasses back to the residence that she had left in the home or at the restaurant earlier. We will also prove that there is a record of violence that has taken place numerous times within the home and with the marital couple. We will show proof of DNA evidence of motive due to controlling and wanting to dictate who his wife Saul was friends with and had sexual relationships with. Thank you.
Thank you, Ms. Clark. Are you ready to
Now I'm going to
proceed?
proceed.
Please.
Ladies and gentlemen of the jury, this is going to be a very important case for you all to decide. So I thank you all for being here. Thank you, Your Honor, for presiding and opposing counsel for litigating.
Sir, please introduce yourself to the jury first before you begin speaking to them.
My name is Johnny Cochran. I'll be Mr. O.J. Simpson. I'm Mr. O.J. Simpson's attorney. He's a famous man. And this is the crime of passion that's being alleged against him. And so, today's case will have a lot of emotion behind it. It's going to be passionate. And in that passion, either me or opposing counsel may misspeak. And so I hope that you don't hold that against my client or any party in today's case. But the fact of the matter is this. The prosecution has a burden of proof beyond a reasonable doubt that my client killed someone. and the defense will show that the prosecution will fail to meet this burden. Unequivocally. There's no question about it. Ladies and gentlemen of the jury, after hearing the evidence, hearing the witnesses, and looking at the facts of today's case, I believe that you'll think that the only logical conclusion is to find my client not guilty. Thank you for listening.
And thank you, Mr. Fuhrman. Mr. Crowline, how would you like to proceed with your witnesses, ma'am?
I would like to call my first witness, Mark Fuhrman.
Okay, and what type of evidence do you have that you're planning on presenting tonight, ma'am?
We have all the evidence that the original trial had. We have the
Yeah,
bloody
do you-
glove. We have over 100 DNA samples, with over 60 having that of O.J. Simpson's DNA in it, inside and outside the residence, in the clothing, on the gates, etc. Would you like to go
And
up and be
Miss-
sworn in?
One moment, please, Ms. Crowline. And Mr. Oldman, what do you have for evidence for witnesses for the court for tonight?
Well, Your Honor, for witnesses, we will be calling Mr. O.J. Simpson's daughter, whose name is
Arnell Simpson.
Are we
Arnell
stating
Simpson.
all of our witnesses at this time?
If you'd like to, ma'am? Yes.
This is also, who are you playing?
Gary Sims.
This is also Gary Sims, who is the DNA and forensics specialist that worked on
Very
the
good.
case.
And who is Mr. Ryan Woe, please, behind you?
That is Mr. Mark Fuhrman, Detective Mark
A
Fuhrman.
detective. Yes, ma'am.
Very good. And Mr. Oldman Music, what witnesses do you have?
Your Honor, as I stated, one of our witnesses will be Ms. Arnell Simpson, and Mr. O.J. Simpson will be testifying in today's case.
And do you have any evidence you're going to planning on bringing in?
Yeah, if I may confer with my client for one moment.
Surely. Ms. Crowline, prosecution, if you please bring your first witness up to the witness stand.
Detective Foreman.
And while they're conferring, detective, do you swear to tell the truth, the whole truth, and nothing but the truth? So help your old gods, new gods, meta-gods, and Chinese food.
Yes, sir.
Thank you. And we're going to hold up for 1 minute while the defendants are having a consultation. And while we're doing that, we obviously have lots of room in this court. So if anybody would like to invite anyone else or people from the other courtroom, you're welcome to do so. I think we have about 10 spots that are open.
Wait.
And Judge Fishbeck, I see that Herbert is in the other courtroom. And Mr. Oldman, I recognize that you have had very, very little time, but we are on a schedule here. So I'm going to allow the prosecution to begin their questioning while you're still in consultation.
Yes,
So
Your Honor,
let's
thank
have
you
it.
very much.
Thank you. Madam Prosecutor, begin your questioning, please.
Thank you. Detective Foreman, can you tell me your place as far as this crime and the things that you saw, et cetera, et cetera?
Yes, ma'am. So my name is Detective Mark Fuhrman. I have been a homicide detective with the LA Meta D Homicide Department for 19 years and 6 months.
And can you tell me the scene that you walked into when you were called to the residence of Nicole Brown?
Yes, ma'am. So when I got there, it was about 2 a.m. There, I had to jump over a fence to let the other detectives in. So I was doing my thing. I was looking at the evidence. But yes.
Okay. And can you tell me about the evidence that you found, where it was, and how you handled it?
Now, ma'am, if I do recall, there was a bloody glove in the back, and we used the alleyways, to traverse the scene. There was just blood everywhere. There was blood running down the sidewalk. I did see two bodies. Okay, two decedents at Mr. OJ's residence.
Can you tell me about any footprints, blood splatter, any other blood evidence that you saw within the vicinity of the crime scene?
Yeah, so there were bloody paw prints. There were bloody footprints. Like I said, blood was practically running down the sidewalks. I've been a homicide investigator for, as I stated, 19 years and 6 months, and this was one of the bloodier scenes that I have been to.
Did you, when you were examining the crime scene, did you see anything impropriety taking place? Were people just tramping over the crime scene? Did you see a lot of instances where it could misconstrue what was taking place there?
No, ma'am. In my experience, the crime scene is pretty much buckled down before I get there, because I'm here to kind of Sherlock Holmes it together. Yes, ma'am.
When you were called, did you know which house you were going to, the ownership? So it was Nicole Brown's house that you went to. Did you know who she had previously been married to? Had you ever been called to any incidences that took place previously at that address?
Objection, Your Honor. I'm going to question the relevance to that.
And Ms. Clark, would you like to address the relevance?
I'm stating that he went in there with no preconceived notions of who he was thinking about being the perpetrator.
Objection withdrawn, Your Honor.
Thank you. Continue, ma'am. Oh,
I had been called to the house one time, okay, before it was a dispute, but I did not know that it was a celebrity's home.
So before, when you had been called, was OJ Simpson there? Or was this something that had taken place that was not a domestic dispute going on?
So when we pulled up there, mind you, the two next to a white Mercedes Benz, they started talking to us like they were the owners, but I can't tell you any further.
Okay, so you were just called because there was suspicious activity taking place in front of the house. It wasn't the house itself?
Actually, yeah, so it was reported as a dispute, but everything seemed okay when we got by the house.
Okay, no further questions at this point. Thank you.
and sir, would you like to cross-examine?
Yes, Your Honor. Permission
And
to approach
again,
the witness.
please- You're welcome to, sir. And again, please state your name for the record.
Johnny Cochran, praying for the defense. You stated that the scene was locked down before you got there. Is that correct?
It's supposed to be, so yeah, yes, sir. That's why.
It's supposed to be. So, just to be clear, was it locked down?
Yes. Yes, I would say so. Yes. It was buckled down like a shoe.
Like a shoe. Now, so I'd like to remind you, you're under oath. You seem a little hesitant. Are you sure the scene was locked down when you got there? No one else was allowed in?
I wish to assert my Fifth Amendment privilege.
Okay. Now, officer, you said that it was, you implied, I'll say, that it was locked down. Now, You were allowed in the crime scene, of course, yes?
Yes, Mr.
And you had access to every element in the crime scene?
Objection, Your Honor.
And that objection is, ma'am?
Relevance, he's a detective. Yes, he had access to the crime scene. That's his job.
Your Honor, maybe heard.
Excuse me, I revoke then my ruling on that, please. You're absolutely right, sir. Go ahead.
Your Honor, this line of questioning is going to the witness's credibility, which is always relevant in any case.
Overruled.
Ask again, officer. You had access to everything in the crime scene, yes?
Yes, Mr. Cochran.
And you said that you had seen. Can you look at me, sir? Thank you. And you said that you had seen a glove in the scene, yes?
Yes, Mr. Cochran. It was in that little alleyway over that fence I jumped to let all my coworkers and other detectives in.
Mm-hmm. And you had access to the glove, of course.
In the course of an investigation, the
Yes or no,
detective
sir?
has to be able
Objection.
to detect.
Excuse me, detective. And Miss.
Relevance,
And
he
Mr.
had
Thank
already
you.
stated that he had been the one that found the glove. So yes, he had access to the glove and he found it, as
Your Honor, may be
previously
heard.
stated.
And sir,
Your Honor, once again, goes credibility, and my next question will wrap up this line of questioning.
thank you very much. You said this here. Overruled.
And you stated that you had gotten there before your fellow officers, yes?
I was the first one to respond on this scene, yes.
So would it be fair to say
Objection,
you-
Your Honor.
And the objection is, ma'am?
He stated that he was the first detective, that he was not the first one. He stated before when he got there, the crime scene was already taped off and locked down. He was
Your
the
Honor, may
first
be heard.
detective, but he was not the first responder.
If I may be heard, Your
Yes,
Honor,
sir.
the witness just testified under oath. He is the first responder. I will not stop opposing counsel from arguing with the witness, but that is what the witness has testified, and I'm questioning the witness on what he says.
Madam Stenographer, it is my recollection that he testified that he jumped over a fence, that he was the first person who had appeared. Is that what the court had, what my stenographer had recorded?
Yes, sir. That is what was recorded.
Any other questions on
Withdrawn.
this? Thank
My
you.
next question is my last question.
Yes, sir.
So, officer, would it be fair to say that you were the first person there, unseen, with evidence, with access to everything in the crime scene?
I wish to assert my Fifth Amendment privilege, and I never said that word.
And detective, regretfully, unless we are planning on prosecuting you, which Madam Clark has not stated in any way, there is no Fifth Amendment right attached to this at this time. Excuse me, let me cancel that. So the answer is your Fifth Amendment would not apply unless, of course, you believe that there's something which is going on that requires you to assert it. Is that the case?
Yes, Your Honor.
Your Honor, if I
Thank
may be heard on that matter. Your Honor, I'm simply asking if he was the first person there, which means no one saw him there, and he had access to all the evidence. That does not make him criminally liable for anything. Therefore, the Fifth Amendment does not apply to that question.
Thank
That's
you.
what he was stating.
And do you have a response to that, Madam Clerk?
No, but I would like to redirect once he's finished questioning.
You're directed to answer that question, sir.
So, officer, would it be fair to say that you were the first one on the scene, so you were alone on the scene first, and you had access to everything there, correct?
So I was only alone just for the time,
Is that
I
a
jumped over
yes
the
or a no,
fence.
sir?
Well, not in the way you're stating it.
Oh, so you weren't first on the scene alone with access to all the evidence?
Excuse me. If you would be so kind as to stop the multi-part questioning and simply ask your question, sir.
Yes, Your Honor. So you testified you were first. You had access to the evidence. About how long were you alone at the scene?
So are you talking about the course of my investigation, or when I hopped over the fence?
First contact. You get there. You let everyone in. How long were you alone on that first contact with the scene?
I'd say probably 10 seconds.
10 seconds. All right. That's all my questions, Your Honor.
Madam
May I
Clerk, would you
read
like to
your-
redirect?
I would, thank you. Detective Fuhrman, again, can you say how long you've been with the police department?
So let me tell you, I have been a detective for 19 years and 6 months.
Objection, Your Honor. Relevance?
And in that 19
Excuse me,
years and
excuse me,
6
madam.
months,
If you'd be so kind as to allow me to rule on the objections before you continue on. Thank
my
you.
apologies.
Overruled. Please continue.
Within the amount of time that you've been a detective, can you tell me how often it is that a detective shows up on a crime scene before it's the regular police?
Ma'am, I would say that would be a very rare occurrence. That's not how, our protocol is arranged to roll out.
Okay, and yet you did state when you were questioned by the defendant's attorney that you were the very first responder on site.
I'm not too good with my words, okay? So I do think that I might have got mixed up with that. I'm just a detective. I detect.
You detect. Okay.
Yes.
And just one more question. Before you showed up to detect, let me do the air quotes. What were there any other police officers on site?
Oh, okay, so there probably were, okay. No, I can't say for 100% certainty because my credibility, I could tell you.
Sir,
what
I
word
would like
didn't
my-
say, though.
I would like his IQ tested. Thank you. No further questions.
Your Honor, the defense would like to recross.
Please do so.
Officer. So, are you claiming that your previous testimony that you were first on the scene is false?
Well, I would like to assert my Fifth Amendment privilege.
Detective,
I will
we've
argue with
already
that, Your
had
Honor.
this discussion. We've talked about this before. I'm directing you to answer the question. Please, just answer the question, sir.
Was your previous testimony that you were first on the scene false?
No.
Okay, so to be clear for the court, because I want clarity
Objection,
more
Your
than
Honor.
anything.
Excuse me.
I would like
Hold on
to
one moment.
find
Yes, ma'am.
my witness as incompetent and mentally unsound to be a credible witness.
If I may be heard, Your
He's
Honor,
clearly special. Thank you.
if I may be heard
Thank
on
you,
that
ma'am.
matter.
Yes, sir.
Your Honor, the prosecution made such a point to say that the detective has been a detective for 19 years. So they've
He
been
did, not
arguing
me.
his competence this entire time. And now that the testimony is arguably against their favor, they want to strike it. We, of course, oppose that motion to strike.
Thank you. The motion to strike is overruled. The jury has already heard your evidence and heard us for this, and they will be the fact finders for this matter.
So would it be fair to say that it would make sense you were first on the scene because you had to hop over the fence, yes?
So there was a fence, okay, and Mr.
And you
Cox
hopped
said
it. Isn't that correct?
I did hop over it.
Yes.
It was in
Now,
another alley.
you said now that you're first on the scene, you had to hop the fence to get in. How is it secure?
Well, it's routine for the scenes to be secure, and I just do with the gathering the evidence, and I used to be a patrol officer, but that was we're 19 years and 6 months into this. So
Who secured it if you were first on the scene, officer?
I'd say the patrol officers, my
The patrol
colleagues,
officers who got there after you?
my brethren.
Okay. That's all my questions, Your Honor.
Thank you. And you may be seated, Miss Detective. And Miss Clark, your next witness, please.
Sims. This is our DNA and forensics specialist, Gary Sims.
Mr. Sims, please put your right hand on the good book. Raise your left hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help your old God, new gods, meta gods, and Chinese food.
Yes, Your Honor.
Very good. Thank you. Please begin.
Profession and how long you have been at your profession.
I am a DNA expert, and I have been in this business for 17 years.
Okay. And do you remember this case that you are currently witnessing upon?
Yeah.
When DNA is provided to you, is there a chain of custody that you verify again and again before you start testing and such to make sure that it has retained its chain of custody?
Objection, Your Honor, leading.
Sustained. Perhaps you'd like to ask
Can you
what is
tell me
chain of
this-
custody?
Can you tell me the steps that you took to make sure that the samples provided to you were intact and not tampered with?
We had it go through what's it called? A lot of testing and stuff to provide, making sure that it was DNA could be used, and it was not tampered with. We have lots of stuff that I had to go through before it could be directly used.
Ms.
So,
Clark,
okay.
if you'd be so
When you
kind as to, if you could please expound upon the chain of custody theory of yours.
So chain of custody would be from the time that the sample is taken to make sure that it is in legal custody where no one not out of the legal or court system has touched it to make sure that's not tainted before it's provided to you.
Perhaps you would like to ask the
All right.
question, ma'am.
Whenever.
I did, and he stated that it was sound and not tainted with.
It was from when it was picked up. From the crime
From when the
scene.
sample is taken,
It has not.
Objection, Your Honor. Who's
When it's
testifying? I'm confused.
Thank you. The court made an inquiry to Ms.
I'll
Clark,
answer the
and Ms. Clark
question.
responded back.
All right. Well, thank
when
you, Your
it's-
Honor.
I'm so confused. When a sample is
Fine, sure.
originally taken by a law enforcement, forensics, or who have you, it starts the chain of custody to make sure that it is sound and it's getting to you without being tampered with. And you stated before that
Yep.
it was not tampered with. Is that true or not true?
Yeah, from the day it was picked up at the crime scene, it has not been touched until we tested it.
And just to make sure that Attorney Cochran and our beautiful judge understands, you do know what the chain of custody is. You know the definition. Is that correct? Can we get a verbal?
Yes.
Okay. So may I ask how many samples you were provided? How many samples you tested for DNA that came from the crime scene?
Several DNA evidence and forensic evidence that linked Mr. Ojo.
Objection, Your Honor. Motion to strike that answer is not responsive to the question. The question was what number? No number was given.
Thank you. Sustained. As a reminder, we are not sticking to the facts of the case. You may
Okay,
testify as you need to. Very good. Thank you.
38. There you go.
And out of 38 of those samples, how many did come back with the DNA evidence to match that of the defendant, O.J. Simpson's?
What's it called? 34% of it all came back as
So-
OJ's.
So there were 38 samples and 34 came back with
Yes.
OJ's DNA. Is there a way to create DNA to set someone up without just outright, sticking a needle in someone and taking their blood?
Objection, Your Honor. Lack of foundation.
Overrule.
No. There's no way.
In your 17-year experience, do you think there could be any setup with planting DNA in 36 different areas to match that of the defendant?
There are ways to match it through hair and fingerprints and such on, but it'd be hard to with blood and such on to get it from the same results as if he was actually he put his hand on it. It wouldn't come back the same as if he had touched it or done something with it himself.
So you're stating that they could plant DNA via hair, but not blood?
So you could the hair would come back not as much, but it'd be harder to make do it like that and plant DNA than if you were to do it. It wouldn't come back the same result.
And one last question. I know that when you're provided the DNA and such, it tells you the location. Can you tell me how many locations DNA was tested from in the crime scene area, inside, outside? Outside, basically.
Like a number? Is that what you're asking?
Right. If you had 38 pieces of DNA that you tested for,
Mhm.
can you tell me how many areas that was part of? So we have a bloody glove. We have the front door stuff. We have, a trail of blood leading elsewhere. So how many places were the DNA tested from?
About 30 different spots around the house, from the blood to fingerprints.
Okay, no further questions. Thank you.
Now pursue with cross-examination, Your Honor. Johnny Crockett, appearing for the defense. Now you said you have 17 years experience testing DNA, yes?
Mm-hmm.
That's a lot of time. And in 17 years, almost 2 decades, would it be fair to say that you have a lot of knowledge in this field?
Yep.
And so you're pretty confident about the facts that you're saying here today, yes? I need a verbal answer.
Yes.
And you've said in the beginning of your direct, the prosecution made a point to ask about the chain of custody. What was the chain of custody?
Huh?
What was the chain of custody of the DNA, Mr. Sins? Take your time, Mr. Sins. Does my question confuse you, Mr. Sins? Would you like me to, rephrase?
Yeah. It's from whenever you get it from the crime scene. How many times it's been messed with the court before tested, or
Who
touched, messed with.
Who got it first, Mr. Sins?
So the law enforcement had it. They were the first people who had it, and then it was sent to my the lab.
And in these reports, you stated on your direct that you get the the location and who got it. Yes.
Hmm.
Now, regarding who got it, does it give you a department, a name, a badge number? What does it give you?
Um, the
It's fine to say you don't know.
Um,
I don't know is a perfectly acceptable answer.
it gives it does it gives you it gives you the location that it was from and who picked,
And who? So it gives you a name?
no.
Does it give you a department?
No.
Does it give you an organization, a body?
No.
Okay, so when you say you know the chain of custody, what exactly do you know about it?
I know that it was picked up from law enforcement from from the crime scene, from the place that it was picked up at, and then sent over to my lab.
You have no idea who in the police department picked it up.
No.
Were you there with law enforcement when they got the DNA evidence?
No.
Were you there when they transported it to your lab?
Objection, Your Honor.
your
Relevance,
objection, ma'am?
everyone knows that he would not be there picking up and talking to people that are picking up.
Your
the
Honor, if I may be
evidence,
heard.
that it's delivered to the lab and it's not hand delivered to the technicians.
Yes, sir. Would you like to say?
On prosecution's direct, chain of custody was a major point in the beginning of the direct. And this
That's
is going to the
correct,
witnesses'
yes.
credit. Yes, it is. Yes. And this is going to witnesses' credibility on that subject.
The objection is sustained. Sir, I've listened to your going back and forth, and everyone is aware, including yourself, that a chain of custody just means that it lists on the inventory sheet of which individual person who has handled that item or their identification information for looking for the log. That generally it's done blind so that people don't know who it is who's handled beforehand, as is the case in many different jurisdictions. So if you would please continue your line of questioning.
Yes, Your Honor. Now, do you know of a chemical named EDTP? EDTA, excuse me.
I'm not familiar.
Objection, Your Honor. Or he should be asking it at all.
Yeah, if I may be heard.
Sustained, sir. He's not being called as a chemistry expert. He's discussing forensics. Please keep it narrow to that individual issue.
Yes, yeah.
Thank you.
Your Honor, if I may be heard on that subject for a moment.
Yes, sir.
My questions will go to the cross-contamination of the DNA evidence, which is within his expertise.
I understand, except you've not established a single shred of cross-contamination whatsoever. All you've done is ask questions of him, which he may or may not understand or may not know.
All right. Understood, Your Honor. So, when exactly did you get this DNA evidence?
Objection.
And the objection is made.
Relevance.
If I may be heard, Your Honor.
Yes, sir.
This goes to the reliability of the DNA evidence to see if it got to his lab in a timely fashion. Reliability of the evidence.
Overruled, ma'am.
How soon? Let me rephrase. How soon after the crime, to your knowledge, or after they came to the scene, to your knowledge, did you get the evidence?
About 5 or 6 business days.
Thank you. That's all.
Objection, Your Honor.
And that objection is, ma'am.
I'd like to object that one, he would not really be aware of when the samples were taken. And also typically if there's degradation of DNA, you would not be able to take DNA samples of it. When you try
Yeah,
to,
for maybe
it
heard.
would be irrelevant and it would not show any type of really DNA markers that would directly lead back to Mr. Simpson.
Thank you. Yes, sir.
As the court has stated and as it's been stated, as it's been stated, the chain of custody is when and who has gotten the DNA evidence. It's on the record that the forensic lab gets, and the witness has just testified that he knows, and he answered 5 to 6 business days. It is to his knowledge, Your Honor.
That has nothing to do with chain of custody, though. Chain of custody is getting it to him. It doesn't mean the time that
In a
it
timely
takes
fashion,
to get
in
to him.
in a reliable fashion.
Overruled, Miss.
If
ma'am.
DNA is degraded, it's not going to be a DNA.
Miss Clark,
They can't
overruled.
test it.
Thank you.
No further questions, Your Honor.
Any further witnesses you'll be calling?
I'm good.
Thank you very much.
I'm good. Thank you.
Sir, your first witness. And you may be seated, sir. And you're released from your subpoena for the court.
Yep. Your Honor, the defense calls Ms. Arnell Simpson to the stand.
Ms. Simpson, please take the stand. And sir, if you please pick up the pace of your questioning, we're already substantially into this case.
My witnesses will be short, Your Honor.
Thank you. Ms. Simpson, please place your right hand on the good book. Raise your left hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you based on our old gods, new gods, meta gods, and Chinese food.
Ms. Simpson, you're muted.
Please state yes or no, ma'am, and you're muted.
Yes.
Thank you. Your first witness, sir.
Now, can you please state your name for the record?
My name is Arnell Simpson.
And can you state your relation to the to Mr. O.J. Simpson for the
I
record?
am the oldest daughter of O.J. Simpson.
Now, are you aware of the nature today of the crime levied against Mr. Simpson?
I do.
And you're aware it's a violent crime?
I do.
Now, do you know Mr. Simpson to be a violent man?
He's not. He's a gentleman.
Have you ever had any instances of physical conflict with Mr. Simpson?
He's my father. Every daughter has conflict with their father, but not angry conflict like this.
Have you ever heard of Mr. Simpson from either him or another person having a physical altercation?
Can you
I can
explain
rephrase
the question?
Yes. Have you ever known of a physical altercation between Mr. Simpson and someone else?
No.
Do you believe Mr. Simpson is capable of a violent crime?
No. He would do
My-
anything for his family.
And would his family include his wife?
Yes, it would.
That's all, Your Honor.
And Madam Clerk, Madam Prosecutor, would you like to cross-examine?
I would. Thank you. Thank you for being here.
You're
So
welcome.
you stated that your father has not shown any type of violent tendencies.
Not to us. We've never seen him be violent to anybody.
Okay. May I ask one question to the judge? What is she witnessing?
Yeah, if I may be heard to respond.
Yes, ma'am. Sir.
The defense intends to call Miss Arnell as a character witness.
Understood.
Okay.
Ms. Clark?
So in the real case, it was his reaction when he found out that Nicole Brown had been murdered.
Mhm.
But that is not the case here. We're just talking strictly character, not from
That is
what
correct.
she saw. Okay.
The jury sees what it sees, the jury hears what it hears, and the jury will make its
Thank you.
decision accordingly.
So do you ever watch the foosball, the football that some people call it?
Where my father plays?
Any foosball.
Yeah.
Would you say that that's a pretty violent contact sport?
Objection on irrelevance. If I may be heard on that matter a little bit
Violence.
further. a little bit further, Your
Character.
Honor. This
I object.
violence that if I may be heard, the violence that the prosecution is speaking of is within a tight and narrow regulation. It isn't a sport. It has rules overseeing it, and it is not a violence of passion or even voluntary as on a case-by-case basis. He gets paid to do it. It is a sport with rules and regulations, and he does not aim to hurt anybody. So I question the relevance of this question.
Counselor,
Your
you
Honor.
opened the door. She's stepping through the door. Overruled. Please
Your Honor,
continue,
I
madam.
can answer that
Prosecutor.
question.
That's not necessary to, ma'am. Just answer the questions that are posed to you. Thank you.
Well, yeah. So I still have to answer this question?
Yes,
Yes.
ma'am.
Okay, that's fine. That's what I wanted to do. In answer to your question, that's a different kind of violent. That's a game. That's not intended to hurt somebody intentionally. They do blocking, block themselves from the other person from hitting them hard.
Did you ever spend any time with your father and Nicole Brown in their house? Did you ever live with them to be able to see the dynamics of the household?
I
Because
visited
you
them
are
for quite a
aware at
bit.
this time that your father the cops were called over 60 times with 8 times.
Objection, Your Honor.
having
There's been
reports
no
filed.
evidence and no foundation set for this claim.
Actually, that was in my opening statement, but thank you.
If I may be heard, Your Honor, on that matter.
Please, sir.
Your opposing counsel said in their opening statement, but and no testimony to corroborate it. And furthermore, that would be a prior act, which would usually not be permitted in a case like this, Your Honor.
Can I answer this question?
Your witness has requested to answer the question. Overruled. Please continue, ma'am.
You're saying they stated that there was over 60 times that the cops were called, but in that statement they never stated when they were called. So just because I've been over there doesn't mean I was over there at the same time that was supposed to
That is
happen.
correct. Right. That's why I asked if you lived in the domicile that he had with Nicole Brown. Did you live with them? Because you are older, so you could have already been out of the house having your own life. Did you share the homestead with your father and Nicole Brown?
No, but I was over there just about every day. The thing is, I've never seen a police come over there. I never seen them
Yeah.
fighting. So
Thank-
I don't know where the reports
Everyone
come
loved
from.
my dad too, but he beat us as well. No further questions.
Objection, Your Honor. Motion to
Don't
strike
put
that
words in
last
my mouth.
That
statement.
portion is stricken. And please, Ms. Clark, not again. Thank you.
My
You may be
hair did
seated,
it.
ma'am.
I have bad
Minutes,
hair.
You may be seated, ma'am. You're dismissed.
Thank you.
You sure?
Huh?
Your Honor,
Any
the
other witnesses,
defense
sir?
the defense calls O.J. Simpson to the stand.
Big sigh.
Mr. Simpson, would you be so kind as to come to the stand? I'm quite sure you can walk a lot faster than that from the commercials. that
Your
I've seen,
Honor,
sir.
he just did a workout video 2 days or 2 weeks ago, so he can surely.
Can we
walk
let the
this
man
bad,
walk
bad
in
knee.
peace?
Ha-
No,
my-
only if he walks quickly.
I have a doctor and I have chronic and bad knees from being hit in football all these years.
I'm sure you do, sir.
Stop talking.
And Mr. Simpson, would you please place your right hand on the good book, raise your left hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help your old gods, new gods, many gods, and Chinese food.
Yes, sir.
You're
Now-
a witness, sir.
Yes. Now, Mr. Simpson, where were you on the night of the crime that happened?
I was out eating with Cato, and after we finished eating at McDonald's, I came home and was taking a nap, and I fell asleep because I'd had a hard day, and I was dead asleep and had to get up to catch a flight. So that's why I was asleep, dead asleep,
And where were you sleeping?
in my house, in the bedroom.
And did you ever go downstairs?
No, sir.
You never left the bedroom.
No, sir. I was dead asleep.
You were dead asleep. So you didn't hear anything throughout this slumber.
No, sir.
And why was that? Just to be clear.
Because I was tired, because it had been a hard day. I had been working on stuff.
Now, we all saw you walking here, and the court made a pretty big deal of it. You walking pretty slow. Why is that, Mr. Simpson?
Over the years in football, I've had knee injuries, hip injuries, chronic injuries, and arthritis. So it's hard to move around, and it takes a lot out of me to move around. And that's why I'd had such a hard day that day. I had done some stuff around the house, and moving around was just hard on me. So I was very tired.
So, excuse this question, but would it be fair to say that you are well past your physical prime?
Yes, sir.
Now, Mr. Simpson, my final question. Now, you've been insistent on testifying. Why?
Excuse me, Counselor, just for the court's edification, can you tell me how many blue pills you take per day, sir?
What is the relevance of this, Your Honor?
You just testified that he's beyond his prime, sir.
I don't think you should question the judge either. I'm
Please
objecting
continue your
for the
question, sir.
judge.
Okay, let the record reflect there was no answer to that question. Don't give me. You've been insistent on testifying in today's case. Why?
Because I want to testify to the jury so they can see there's no way that I would kill the wife of my children. I love Nicole, and I wanted to be with her. So this is ridiculous.
Thank you, Mr. Simpson. I understand how hard this is. I'm sorry you have to be here. That's all, Your Honor.
Thank you. Mr. Clark?
Thank you, Your Honor. So you stated that you did a lot of hard stuff and then went to the McDonald's for the dinner with the Kato doodly doo.
Yes, ma'am.
Doodly doo.
Can you tell me what that hard stuff was?
Just moving around, getting stuff, straightening up stuff. With my bad hips and knees, bending down is rough and takes a lot out of me. My heart rate raises up higher, and then it just takes a lot out of me.
So I assume you were not playing with white balls.
Objection on irrelevance?
Sticks, also known as golf.
Well, he may have been playing with white balls, may have been playing with blue ones. I mean, we just don't know, sir.
Yes, and he could be on the moon. What is the relevance of this question?
The relevance is he wasn't just, puttering about. He was playing golf. Golf is a hip swing. It's an arm string. It's holding the doodly doo thingy and hitting the
Golf
white
club.
balls or the blue balls, whatever balls you want to hit. We do like
That
that.
was
If he's
much
playing with his
earlier in the
little balls,
day.
let's move on.
That was much earlier in the day, and all. So
Keep drifting. And may I ask, so you stated that you had bad knees. What does bad knees have to do with this?
Objection, Your Honor. That question.
Excuse me, Mr. Clark, please don't make those types of motions in this courtroom. That looks quite obscene, ma'am.
Well, he was playing with his balls earlier, so.
Let's reflect golf balls. Okay, let the record reflect.
What
It was
else
a
would we
golf
be
ball.
talking about, sir?
Yeah, just
You have a dirty
baseballs,
mind, Mr.
basketballs,
Cochran.
anything, any other sport. I want it to be clear. It's golf.
Please do not bring up those types of comments in my courtroom, sir.
Baseball. I didn't know we hated baseball.
Please continue,
So-
ma'am.
What does bad knees have to do with having a upward swing with your arm and coming down upon it?
Objection, Your
not
Honor.
like
The
you
witness
had to
has never
jump.
stated that the witness never directly
He
stated.
just
that
stated he
he-
had bad knees.
If I may finish my sentence, the witness has never stated that his injury prohibited him from doing anything in particular. So, opposing counsel is attempting to impeach my client on something he never said.
Overruled. Please continue your questioning.
You did state that your physical injuries proclivited,
Prohibited, ma'am.
bleh. Thank you. You killing your ex-wife and the very, very sad waiter that was returning glasses. Is that true or not true? Because that is what you stated.
It's hard for me to move around. So how I would be able to kill two young people like that is beyond me. I don't know how you come up with that. And especially my wife of my kids.
Isn't it true, sir, you wrote a book of stating that?
Yes, yeah, that's after the
I did it.
that's
This
the
is
court.
how I
That's
would
after the
do it.
trial.
That
After
was
the trial, Your
after,
Honor.
yeah.
Yeah, that's years later.
Time travel is supposed to be
Doesn't
for
mean
after the
money.
fact.
Very
And
good.
all that money went to the Browns.
Objection, Your Honor. Motion to strike
Since
all
you
of this.
killed
Now
their
she's making
children.
points off of it. Motion to strike. All this is improper.
Sustained.
So, Mr. Simpson, can you honestly tell me you went to McDonald's and then went straight to sleep? Because that is really bad food. It would hurt my
Ew.
tummy.
Objection, Your Honor. Argumentative.
Sustained.
I have no further questions.
Thank you.
The defense has no redirect, Your Honor.
Very good. You may be seated.
The defense rests at this time.
Okay.
So should Mr. Simpson.
And
My God.
clearly.
Do you want me to carry you?
And Ms. Clark,
No, I'm an
is there
attorney.
any
I have to
other evidence which you would like to introduce to the jury at this point?
No, Your Honor. They were not on the call sheet beforehand, so I.
Yeah, they weren't on a call
Right.
sheet.
And we're at the hour mark. We're at the
Yeah.
hour mark.
I think both counselors are ingredients here.
Who is the other witness?
I don't know, Your Honor. I don't know
Judge.
of any other witnesses that
Me.
exist.
Let's see what Wendy.
What would Wendy be testifying to?
And we didn't
Yeah,
really get into any of that.
Your Honor, the defense does not wish to question the witness.
Then that answers the question as long as Miss Wendy, if you're okay with not being called. Very good. Thank you. Then Miss Crowline, please make your closing argument to what's left of our jury.
Thank you, what's left of our jury, for being here. I think you all look beautiful. Love your necklace. Love the hat. Love your little bow. I would just like to say that I think our evidence clearly shows that Mr. Simpson was the perpetrator of this crime. Again, he was called, the police officers were called numerous times, 8 having a police report filed stating that there was domestic violence in the household. And we all know there's not just a little baby domestic violence, right? It starts small and then it blows up. There were DNA evidence in multiple locations around the crime scene. That's not something you can just mess with. I know that, our little racist Mark over there, he may not like OJ, but he also didn't get a vial of blood and plant it in numerous locations. Although he is a little special, he was not the first responder. No detective is a first responder in any case, unless you killed somebody. But he didn't. He's not up for trial, but he is a racist and we don't like him very much. We'll take care of him later though. But Mr. OJ, he did it. If the glove doesn't fit, it doesn't matter because he still did it. It's a glove, for the love of Christ. It was a leather glove. And you know what? In humidity, it shrinks. He has big hands. And as he stated, he ate at McDonald's. Do you know how much sodium is in that? His hands swelled up like the Hulk's. I ask you to please give the Brown family justice and send his ass to prison. Thank you.
Thank you, Ms. Clark. Sir.
Ladies and gentlemen of the jury, thank you all for listening. I know it's quite a pleasant summation. Don't you all agree? Now, a lot of things came out during that closing summation, which I found quite odd. No one had mentioned the detective's racism, but if the prosecution wants to damage their own witness, if they don't find him verifiable, I guess you got to trust the prosecution in saying that their own witness is not credible. Ladies and gentlemen of the jury, the prosecution agrees that one of their star witnesses, one of two who testified, is racist. Clearly, a bias against my client. And the prosecution stated that, a detective is not a first responder. The prosecution must not like this detective. Because, ladies and gentlemen of the jury, you will recall that the detective several times stated he was the first responder, said he was first one on the scene. In fact, he had to hop the fence to let the others in. The prosecution does not like this witness because they have done nothing but call him a liar and a racist. And the defense, of course, agrees. Because the detective had to hop the fence to let them in and doesn't know if he's first respond. He went back and forth. You all saw on the stand, he was hesitant. He didn't want to answer. He's a liar. We all know it. And then the second witness they called was the DNA forensic expert, who really didn't testify much to who the DNA matched to. There was one comment about it matching to my client, but then, right after, we hear him testify that the chain of custody could not be verified. So, we have a witness.
Objection.
And that objection is, ma'am?
That was not the case. He stated that the chain of custody was intact. He did not state that it could not be verified.
Your Honor, the facts have been argued, and I gave opposing counsel courtesy not to object, although several things that were not in the evidence came out. I would like that same courtesy, Your Honor.
Sustained, ma'am. Please continue.
Ladies and gentlemen of the jury, the DNA expert could not verify any of his testimony. You saw how he was on the stand. Just like the detective, he was hesitant. It took him up to a minute to answer a simple question. Question about his job, which he says he's been doing for 17 years. You have a liar of a witness who everyone knows is a liar, and you have a witness who barely knows what he's doing. This is a murder case. My client's freedom depends on your verdict. Are you going to put a man away for a liar and someone who's incompetent on his job? I don't think you should. The burden was beyond a reasonable doubt for the prosecution, and they've absolutely failed to meet that burden. And the only logical conclusion is to find my client not guilty. Thank you for listening. Thank you, Your Honor, for presiding, and thank you, opposing counsel, for litigating.
Thank you, Counselor. Ladies and gentlemen of the jury, you've heard the evidence. You've seen the witnesses testify. At this point, the court is going to charge you to determine guilt or innocence. As the counsel for the defendant advised, the standard here to be able to prove is beyond a reasonable doubt. It doesn't mean beyond all doubt. It means a reasonable doubt. You, as reasonable people, determine whether or not there's a doubt, or whether or not that you believe that the plaintiffs, the state, have proven beyond the reasonable doubt that this party is guilty of what he's accused of, murder. Are the three of you ready to render a decision? And mind you, this is Medicourt. It does not need to follow the decision of the actual courtroom. You've heard far, far less and spent far, far less time than those individuals did. So it is up to you to determine what you've heard tonight and only tonight. Are the three of you ready to render a decision, or do you need a minute? 1 minute is.
I'll tell you one word that
This is where I'd like to be able to cue the music going. Dear, 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 dear.
I've never said that word ever. Maybe once or twice.
Have you made the suggestion to Herbert for that yet?
It's actually, the problem with it is in our regular courtroom that there's no space for additional coding.
Also, any 5-year-old that got on the bench would press that button again and again and again and again and again.
They wouldn't know what it is, but probably.
maybe you have to hit certain buttons in combination to make it work. A hidden one.
Interesting. Ooh. That would be more coding.
Well, but coding actually takes less space than other things, so they could.
Well, yeah,
do
but they said they were out of
coding and
it,
get
so they
rid
have
of
no
it.
space.
There's
Yeah,
no
But
space.
they
Right?
could
no
take
space.
stuff out and put code in. Is what I'm saying.
Thank you. Ladies and gentlemen of the jury, it appears that there is someone hold out. Is that correct? We'd like to get that decision rendered. It is 10:15.
Oh, this is awful.
Just waiting.
Can one of you beat
The
the other
waiting
two
is the
to
worst.
be able to do this? Still need another minute. Okay.
It's your life.
Maybe cry this time if you're found not guilty. Show some emotion.
That's right.
Let's go
That's
around.
right. That's right.
And don't write any books afterwards.
Mm-mm.
Especially saying I killed him.
If I did it, this is how.
Yeah.
But you didn't. But you didn't.
Ooh, they're really debating that
They
really,
really are.
hard, aren't they?
And I love it.
They
This
are
is
hard at
great.
work. That's excellent.
Yeah.
Yes.
Are we ready? Okay. So
Do you want us to push the button? Oh, we're gonna
We're
push
going to
the
do that
button.
now.
Okay.
Go back in. Let's see if we can do this. Whether
It'll be okay.
it works.
It'll be okay. We'll appeal the bastards if they find you guilty.
Whack veteran, please vote. Please hold your hand in there. Did it disappear?
Did you say that, Desert Rose? You are like your daddy. You are violent.
Oh,
We'll kill those
Oh,
people if
stop
they find
tampering.
them guilty.
Stop tampering.
Shocker.
Mhm.
Get a shot of OJ having emotions for once.
A hung jury. Okay.
Oh my God.
Oh,
Two
wow.
not guilties and a
And-
guilty.
Mrs. 1985, would you come out, please, and tell the court why you voted the way you did?
Yeah, I voted because of his knees.
And you
That's
voted,
why.
what did you vote?
I voted not guilty. I'm sorry. Not guilty,
Not guilty.
because I agree that OJ is old and busted. I mean, you know, anything's possible,
but you know
but
that
I'm
he,
Don't argue with them. It's
like
over.
2 weeks before.
Where are you?
No, I'm just talking to her. It's a hung jury. It doesn't
Okay,
matter.
Hold on, please. And
They
sir,
usually go
would you
back to
please
the
come out
lawyer.
and tell us.
I voted not guilty going with his decision. And also, the DNA was a little bit confusing to me, so I just decided. to go
yeah,
not
I have to agree with that.
Very
I
good.
have to
Mr.
agree.
Veteran, would you please come out and
Oh, you
advise?
finally got in
I
here.
agree
huh?
with that too.
I voted
Hey.
guilty because the
Get her out of
plaintiff
here.
had the DNA that was directly against OJ, and
Mhm.
OJ's defense did not
There.
dispute the actual results.
Okay,
Very
man.
good. Thank you very much.
man- oh,
true.
man.
They have to
I
prove
think
it. We don't have to
Oh.
disprove it.
I just
That's
I
great.
just wanted to
Right.
ask, when you said the DNA, I had asked you the DNA from where, and you said all the blood evidence was his. But
Well,
is
the-
that what you said?
But
Is that what you said?
I said
contamination-
that they said that what blood came back pointed
What's
to
the
his
procedure? Because
DNA.
if the procedure is to go back and
His
deliberate, I'm going to
DNA
object
was
like hell.
in there.
34 out of 30.
No,
of the
it's done. It's a
samples
hung
came
jury
back,
no matter what.
but it
Now,
was
you
your. You
there
live
were
there,
actually
so
over
it could've
100
been your
pieces
blood,
of DNA
like,
sent to the
anyway.
lab with
and it was
68 being
contaminated.
DNA exact matches for OJ Simpson in the real
The
trial.
answer is it's a hung jury.
68 out of 100 DNA samples.
Ladies and gentlemen,
Yeah, but we're
Well,
not
this
we're
is
not doing the
incredibly
real
again-
one.
while this is
I know.
incredibly against the normal procedure, normally a hung jury gives the prosecution another chance to be able for another bite at the apple, to be able to recharge and to be able to do this accordingly. However, because of the nature of this circumstance, I have to tell you that I agree with our two individuals for this, and I believe that he is not guilty based on what we had shown today in Metacourt. That Madam Clerk,
My mock
I
trial
believe that
experience is
absolutely-
manifesting.
That you killed your case by that no point was any racial comments brought out. You should not have brought that out, and I think that
Go,
hurt your case
OJ, go.
tremendously. But
I'm okay with that.
Mr.
That's
OJ,
why I asked for him to be stricken, period.
Right.
Go,
I did
Yeah,
not
I
choose
didn't want that.
who my witnesses were. They
Well,
were
you-
chosen
well,
for
no one
me.
said he was
I would have
racist.
wiped him out to begin with.
There you go.
We were,
Prosecution.
we were
Yeah.
doing,
Good
no, no,
trial.
we were
Mr.
doing
OJ,
this
you
did a
one,
good job.
not the real one.
Ladies and
Good
gentlemen,
trial.
You did.
You did.
Great.
Right, all of you.
Good job,
All of
good
you
job.
did
Thank you for
so.
litigating, counselor. Thank you for litigating.
Yes.
Especially the
Yeah,
last
great
minute,
case.
both of you.
Right.
And you.
Thank you.
All right, we did
Mock
it.
trial county
Yay.
champion right here. County champion, state
Yeah.
finalist.
Man, OJ,
Now what?
you're going down.
Smoke break.
OJ, we're
Smoke
gonna
break.
get you in the next